Good morning, everyone, and welcome to the Moorcrofts Spring Employment Law Update. Thanks so much for joining us today. My name is Matt Jenkin. I head up the employment team at Moorcrofts, and I'm delighted to be joined today by my colleague Lindsay Abbott. Lindsay is an associate in the team, and I know is looking forward to giving her thoughts on various issues on employment law as we go through. Just some housekeeping before we start. We're going to aim to finish by 11. We are trying to build a little bit of time in for question and answers, but just in case time is tight, if you'd use the question and answer function to ask your questions, that'd be great. It allows us to keep track of them. Also means that we can, if we don't get time to answer all of them, we can do a kind of Q&A fact sheet to send out as part of the follow-up as well. And just a reminder, we are recording the session. Well, that's great because it means we can send out a link to the recording shortly after the session, next couple of days or so, along with the slides. It does mean if you can't stay for us for the entire period, then you can watch us at your leisure later on and catch up. And if you watch us all the way through but really enjoy it, then you can obviously watch us again, a little bit like iPlayer and catch up. Hopefully we'll keep you as entertained as that. So let's look at what are we going to talk about today. Well, and hopefully you can see my slides. No doubt someone will shout with it with a Q&A or comment if they can't. But we're going to look at two aspects. Firstly, I'm going to look at employment law changes, the current state of play. Certainly, as I say, an interesting time to be advising on employment law. And then Lindsay's going to look in the second half of the session at some case law updates and some important points to note. And there's been some very interesting cases that I know Lindsay's very keen to talk about. So, employment law changes, the current state of play. I think we're in a real state of flux with employment law changes at the moment. And that's due, I think, to a number of factors. Certainly the amount of proposed employment law reform could be seen as somewhat overwhelming. I think there's 10 or 11 pieces of employment legislation that could hit the statute books or are going through some form of consultation at the moment. So that volume, I think, creates some uncertainty. What's going to be introduced and when? And hopefully I'll look at some of those key changes and we'll talk about perhaps whether or not they will actually be introduced. I also think the general election is causing some uncertainty. What we're looking at, October 2024, perhaps for an election. Now, I'm not going to try and predict the outcome of the election, but say we have a different government, then I think the makeup of employment law could be very different. It could mean that some of the changes that have been introduced, particularly around strike action, get overturned, and it could mean a different legislative timetable. So certainly, I think that could cause some interesting issues. And also the EU reform bill. I don't think I'd be doing, I'd probably be drummed out of the Employment Lawyers Association if I didn't talk about the EU reform bill when we're talking about the current state of employment law. So all those things, I think, have created this state of uncertainty and flux. And talking about the retained EU law bill, it certainly is the elephant in the room, because until we know what is happening with regard to this piece of legislation, it's difficult to predict exactly what the state of employment law is going to be, say, come the 1st of January 2024. I don't think I'm misrepresenting it to say that this has the potential to be the biggest change to employment law, certainly in my practicing career. And the reason why is because, and we talked about it in November 2022 webinar, is it will lead to the turn off of all EU derived legislation. And that's not just employment law derived legislation, that's all EU legislation. I think there's over 3,000 pieces of legislation and regulation that could be removed from the statute books. And they'll be removed on the 31st of December 2023, which is the sunset date that's been set in the bill for removal of all that legislation. Now, it's fair to say that the government has and can, under the bill, take steps to preserve particular pieces of legislation, but that's not that straightforward. If we take holiday pay, for example, the government could restate the working time regulations which deal with statutory paid holiday. But what the bill actually does as well is it removes all those interpretive principles that we've grown up with now in relation to holiday pay. So all those European cases which established that holiday pay isn't just basic pay, but things should include elements of commission and bonus and overtime. Those are interpretive principles, which the government would have to decide whether or not it's going to introduce those into any restated piece of legislation that deals with statutory paid holiday, similar to the working time regulation. So it's not, I don't think, simply straightforward as preserving legislation without then having to do some further work to bring those interpretive principles across. That's a hugely time-consuming exercise. I've just talked about one piece of legislation there, and times that by over 3,000, and you can see the timescales and the issues that we've got. But certainly it will have an impact on employment law. Working time regulations I've mentioned, not just holiday pay, but things like 48-hour working week, rest breaks, rest periods, night work restrictions, even restrictions on young workers. All those would disappear. Now, I don't think the government necessarily would want to jettison all of that employment protection. Certainly, I think electorally it may be difficult for them, but also from negotiations and further relationship with the EU, it would be difficult because that would, I think, be seen by the EU as weakening worker protection in the UK, which could have implications under the various agreements that have been reached. Would also say goodbye to things like the agency worker regulations, which I'm sure some employers would welcome, given its complexities around giving basic protections and terms and conditions to agency workers. Also, and some of you may know if you've heard me speak before, the transfer of undertakings, protection of employment regulations, 2P is very close to my heart. I think I've been described as a 2P anorak on occasions, which I take as a badge of honour. But 2P would disappear. So those rules and regulations which deal with the automatic transfer of employees on business transfers and service provision changes and outsourcing would disappear. And actually, the transfer regulations also highlight some of the complexities of this bill, because some of you may remember back in 2006, when 2P was last amended significantly, the government chose to introduce at that time some additional provisions with regard to service provision changes. Now, that was because at that time, most of the disputes around the application of 2P were around outsourcing. And it was very unclear as to whether or not 2P did actually apply on an outsourcing or not. I could point to half a dozen cases which said that it did and half a dozen that said it didn't. That created uncertainty. And that was, I think, welcome clarity when service provision change provisions were introduced. But that was a decision of the UK government to effectively gold plate the Acquired Rights Directive from which 2P comes from. So are we going to be left in a situation if 2P disappears with a rump of legislation that just deals with outsourcing, transfers and a service provision change? And again, I think that just shows you the complexity of this proposed piece of legislation, which on the face of it is quite simplistic, but I don't really think necessarily everyone's thought through its full implications. So what will happen? Well, we've had radio silence from the government. I talked about this in November 2022 and was slightly concerned about the timescales given the sunset date of the end of December this year. But now, we're nearly into May, aren't we? We still don't know what the government's plans are from this. And it's not like it hasn't been pointed out to them. The Employment Lawyers Association have done a great briefing document. Now, Employment Lawyers Association is apolitical in this. They're not saying whether it's a good or a bad thing to introduce this bill. What they're talking about is the impact. They've made it very clear to the government what the impact will be, but we haven't seen any response from this. In fact, what we've seen is some reports. I read a report in The Guardian back at the beginning of April that the government's retreating from its plans. Now, whether that's they're going to remove the EU reform bill altogether or water it down, I'm not sure. I think what they might have to do is use a provision in the bill which allows them to push that sunset provision back from the end of December to the 31st of January 2026, just simply to give themselves more time to actually decide what legislation they want to keep and in what form. So I think with the retained EU law bill, whilst it has the potential to be the biggest change to the employment law landscape over very many years, it's still a question of watching this space. And I'll make sure I keep you all up to date as to where we are as soon as we get any more information. Some things that we do know they're looking to change around flexible working. We've had the consultation on making flexible working the default position. I actually think that's a slight miscategorization of the consultation, because I think if you talk truly about making flexible working the default position, it would be a right to work flexibly. That's not going to be the case. It's still going to remain a right to request flexible working. And for example, the 8 business reasons that employers can rely on for not making a change are still going to be valid. They're not looking at amending those. And so, sometimes I rather flippantly say to employers around flexible working requests, if you've got a good business reason and you can't think that it falls within one of those 8 business reasons set out in the regulations, it's probably not a good business reason, because they're so wide that I think most decisions could fall within that. That's not going to change. What we will see, though, is I think some tinkering around the fringes of the right. So it becomes a day one right rather than anything that requires a period of service qualification for. And that's, I think, helpful. Although I think most employees and employers would want to get any um, uh, flexible working arrangements ironed out so they could be implemented right at the start of employment if that's what someone wants. So um, I think it's helpful, but I don't think necessarily employees on day one will necessarily make that request. What I do think is helpful is changes around consultation. So if an employer is thinking of rejecting a request for flexible working, there's going to be an obligation to consult with the employees about that and consider alternative options. And I think that'll be helpful, although in my experience, most employers, as part of treating requests reasonably, will build in some kind of consultation process anyway. But I think to have that codified is certainly going to be useful. Other procedural changes, things like reducing the period of time to deal with requests. So we're going to deal with those requests within 2 months, not 3. So trying to make the regulations a very light touch. Although some of you may remember when flexible working was first introduced, there was a fairly comprehensive process by which you had to go through. That was abandoned and replaced with this concept of dealing with requests reasonably. This is going to be even a lighter touch, I think, on that sort of regulation. In terms of timescales, it's that dreaded phrase, when parliamentary time allows. And I'm not sure, given all the other pressures that the government's facing, that parliamentary time will allow this change anytime soon. But definitely want to keep an eye on. Certainly, you'll need to update flexible working policies to deal with any changes once those come through. Trade unions and industrial action. It's certainly the case that industrial action has dominated the news headlines. Certainly, we've seen employment law hit the news headlines as a result. It's been a while, actually, a good while, since any employment law updates really, I think, have had to cover industrial action, which just shows, I think, how prevalent it is at the moment. The government's introduced a number of things to try and reduce the impact of strike action, certainly. First one is the Transport Strikes Minimum Service Levels Bill, which is currently going through Parliament. And what that's going to do is introduce this minimum service level in transport services during industrial action. So employees and unions will have to ensure that a certain number of employees don't go on strike and maintain those minimum service levels. Certainly will have an impact for employees and trade unions and their members. Employees who are required to work to maintain those levels but go on strike could be dismissed and lose unfair dismissal protection. Trade unions who don't take reasonable steps to ensure that those service levels are met could also lose the immunity from claims that they currently have, this so-called kind of immunity from tortious liability. So things like being sued for inducing a breach of contract on the part of their members. That could disappear, and unions could face significant financial penalties as a result. Now, it's only impacting transport services at the moment, but I'll be interested to see whether the government feels it should be extended out to other sectors, education, health, other public utilities. And who sets the minimum service levels? Well, those are set initially between the employer and the trade union by agreement. If they can't reach that agreement, then it's for the Central Arbitration Committee to set those levels, with the government having the ultimate power to set them if that was necessary. Will it be effective? I think it will certainly minimise to a certain level transport strike disruption, but I don't think it will reduce it and remove it entirely. And my experience with trade unions is that every time that the government changes the rules relating to strike action, normally to make it more difficult, unions are quick to adapt to that, and I've got no doubt they'll also adapt to this. So you may see a slight reduction in the effectiveness of strike action, but I don't think it'll be significant. Um, Also, we've seen the rules change, allowing agency workers to replace striking workers. That used to be prohibited. It's no longer the case, although I haven't seen any statistics on it. And I don't think the take up of that by employers who are facing strike action is particularly great. For example, in the transport sector, how realistic would it be to bring in agency drivers to replace the train drivers who are on strike? I think, very unrealistic. And that piece of legislation is actually now subject to judicial review. And it's a wait and see, I think, to whether or not those regulations are overturned and we go back to the situation where agency workers aren't allowed to replace striking workers. And what I think is going to be important is this new duty to prevent sexual harassment that's contained in the Workers' Protection Bill. Now, there is a question mark, and I'm seeing increasing commentary in the press around whether or not the government's going to push through with all of these changes, or perhaps lose some of them or all of them. But even if those changes aren't introduced, I do think that employers need to revisit their approach to preventing sexual harassment in the workplace. I've been talking to people recently, and I always think it's one of those aspects of employment law that you think actually we should have dealt with by now. But we go back to the Me Too campaign, and even right through now to the current time with the scandal affecting the CBI. It's clearly the case that sexual harassment is still an issue for many employers. So regardless of whether or not this piece of legislation is introduced, I do think that employers need to revisit their approach to this and make sure they're taking the appropriate steps. What the new bill will do would be introduce a liability for third-party harassment. So by way of example, if you're an employer and you run a call center, one of your operatives is rung up by a customer and that customer sexually harassed them, you could be held liable for that harassment if you haven't taken reasonable steps to prevent it occurring in the first place. Now, that's a reintroduction of a liability that was present, I think disappeared 2013, 2014, if my memory serves me right, but would be reintroduced. Also, for the first time, we would have a new duty imposed on employers to take all reasonable steps to prevent sexual harassment of their employees, with the incentive to employers that if you don't and you breach that duty and an employee brings a claim, you could see an increase in compensation of up to 25%. Now, what I do think this new duty will do, I think will really concentrate employers' attentions on training, making sure that the appropriate training is in place in their organisation for managers and employees around preventing sexual harassment, making sure procedures are up to date, and making sure that employers take a consistent approach to this. So I would say, regardless of whether or not this new duty is introduced, bearing in mind the current landscape regarding sexual harassment claims, I certainly think employers should revisit their approach to this anyway to make sure they're doing all that they can to protect their staff and also protect them from liability that currently exists. Carers leave bill, probably one not to get that excited about because it only provides for 1 week's unpaid leave per year for those employees who are providing or arranging care. Now, I think that's a welcome addition to protections, but talking to many of my clients, I think they provide that anyway and probably provide paid leave in those circumstances, even if it's done on an informal basis. And I find many employers are hugely supportive on this, but to have it codified would be useful. What for me is interesting from a technical perspective is that it's a government-backed private members bill. So this isn't government-sponsored legislation. This is using the timetable that's allocated already in Parliament to private members bills to actually force through a piece of legislation that I think the government could introduce themselves, but can't because of the limited bandwidth they have to get through these sort of changes. It's currently with the House of Lords. When it'll hit the statute books, we're not sure, but certainly one to look at as part of that suite of kind of family-friendly policies and procedures you may have in place. Similarly, neonatal care leave and pay, I think is a sensible addition to that suite of protection and additional benefits for family-friendly policies. 12 weeks neonatal leave, you will have to have a 26-week service requirement, and there'll be a statutory neonatal pay to go alongside that, which will be at the level of statutory maternity pay, I'm sure. It's going to be enforced by April 2025. And again, whilst I think it's a welcome addition, my experience is that employers tend to be hugely supportive of employees who find themselves in a position of a newborn baby who's having to go in for some neonatal care. So again, a welcome addition, but I don't think is necessarily groundbreaking, but one that you need to be aware of for sure. And what I think is potentially a significant extension, but perhaps not as significant as extension as some people want, is extending redundancy protection for women and new parents. Now, this will see the current priority right, which applies to maternity leave only, being extended. What do I mean by the priority right? Well, if you've got an employee who's on maternity leave and is at risk of redundancy, um, they have the right to be offered suitable alternative employment um, as a priority where that alternative employment is available to any other employee. And that does give a kind of positive form of discrimination. Only applies during the maternity leave period. And there is a view that that's used cynically by some employers who are running redundancy exercises just before someone goes on maternity leave or just after they return to avoid this obligation of this priority right in offering this alternative employment to employees on maternity leave. We're going to see that um, protection extended. So it'll start from the date an employee notifies their employer in writing of the pregnancy, and it'll apply right through to 6 months after they return from maternity leave. Now, that is a significant extension of that protection, but it doesn't go as far as ring fencing employees on maternity leave from redundancy. That has been called for, but I think would be hugely problematic because there will be some genuine redundancies that would need to take place that even if you're on maternity leave doesn't mean you should be ring fenced from. However, as with all these things, you do have to be very careful when running redundancy exercises that involve those on maternity leave. Definitely one that you should take some advice on because you can get yourself into difficulties, not least around this priority right. The bill is at the House of Lords stage at the moment, so again, watch this space for when it goes live. Fire and rehire, changing terms and conditions is also going to be the subject of some change. I've talked about this previously, and fire and rehire is, of course, the reference to a mechanism by which employers can change terms and conditions of employment. And the way that they can do that is to give an employee notice of termination of employment with an offer of re-engagement on new terms at the end of the notice period. If the employee accepts the offer, their employment continues at the end of the notice period on those new terms with continuity of employment preserved. If they turn down that offer, then on expiry of the notice, their employment terminates. And if they've got more than 2 years service, they could bring an unfair dismissal claim. My experience, though, is that if an employee's been through a fair process, such as consultation, and has a good business reason for introducing the change, employment tribunals are reluctant to make findings of unfair dismissal. Now, I think that it's fair to say there's a feeling that fire and rehire has been abused. Certainly, it's hit the headlines recently. Probably the most famous one was last year with the P&O dismissals. You remember P&O dismissed en masse a large number of its employees who were working on various ferries. Now, actually, the P&O dismissal isn't a classic fire and rehire because P&O didn't fire and then offer to rehire the workers that it had given notice to. It actually hired agency workers on reduced terms. So not quite the classic fire and rehire, but nonetheless, still one that I think triggered this response on the application of fire and rehire. So what we're going to see is a step-by-step process introduced, a code of practice, to ensure that before fire and rehire is introduced, employers explore all the options. And so this code of practice, I think, is interesting because it will codify the approach that employers need to take. But what it won't mean is that fire and rehire is prohibited, but it's seen very much as the tool of last resort. And it'll also apply in all fire and rehire situations, not just large scale, sort of akin to collective redundancy consultations of, say, 20 or more employees. So I think employers will really have to get to grips with the regulations and the code of practice, because if they don't, they're going to face a 25% uplift in compensation. So I think any fire and rehire exercise, once this code of practice is introduced, we'll see employers really having to make sure they go through that code and understand it when using it as a way of achieving change to terms and conditions of employment. Failure to prevent fraud offences. Well, this to me is it's a relatively new thing. It was only talked about a couple of weeks ago. And I just thought it was interesting because it shows, I think, what sometimes we may think it doesn't have any employment law impact, but I think will have an employment law impact. And that's this new failure to prevent fraud offence for large organisations, which will be a Companies Act definition that's introduced. And an organisation will be liable, therefore, for an employee who commits specific fraud offences that benefits that organisation, and the organisation didn't have reasonable fraud prevention policies in place. It could lead to an unlimited fine. We're not going to see it introduced until the government published guidance on reasonable fraud practices, but it's a potential criminal offence, so definitely one that employers should be aware of. Now, okay, it only applies to large employers, large companies. But what we've seen, certainly with, say, IR35 and the Bribery Act, is large companies tend to flow down those obligations down the supply chain to smaller employers that they're dealing with, because they want to make sure that they can rely on those requirements if they're subject to any potential issues. So what we see, I think, is it's going to apply, I think, further down the food chain. And I think as employers, what you need to do is revisit your policies, contracts, training around fraud prevention, because I think that's going to be a key part of reasonable fraud prevention practices. What training are you putting in place for your employees? And certainly talking to a couple of my HR contacts at the moment on the back, certainly, of the announcement around this. I know they when they're looking at their training plans for the rest of 2023 and into 2024, fraud prevention training, I think, is going to be towards the top of that list, perhaps alongside revisiting their sexual harassment training as well, on the back of what I've talked about previously. And finally, we'll see the April rate changes that normally come through. You'll see the extract just on the right-hand side of the slide. We've actually got a flyer that we're going to produce, or we have produced. We're going to send that as part of the follow-up, so you can print that out and look at it at your leisure. Use it as a mouse mat, put it on your keyboard, give it away as a present if you think anyone would be suitably impressed by that. So don't feel compelled to scribble everything down. Just some of the headlines that I think attracted my attention. So the national minimum wage rate, well, that's going to go up, or has gone up actually in April, hasn't it? So the headline rate for the national living wage rate, which is 23 and above, that goes up from £9.50 to £10.42. That's a huge increase, nearly £1. I can't remember that sort of level of increase since the national minimum wage has been in place. I'm sure people can correct me if they think there's been a bigger increase. What that means, I think, is it used to be with the national minimum wage, many clients didn't really pay much attention to it because their salaries were at such a level that when they worked out the hourly rate, they were way above the national minimum wage rate. But actually, £10.42 is significant when you work it out as a kind of an annual salary. And I do think it's worthwhile just revisiting perhaps your salary bands, just to make sure there's no national minimum wage issues. You don't want to fall foul of those regulations on a technical requirement. So definitely worth checking. Statutory sick pay, that increases from £99 to £99.35 to £109.40 per week. Again, it's an increase. We could debate, couldn't we, statutory sick pay and whether it's an effective means of dealing with sickness absence. I don't think particularly it is. The government's going to try and address this via other means. Certainly, we may see over the next few months their plans in relation to increased occupational health support for employers come to fruition. So let's watch the space on that. Statutory maternity pay and the other family-friendly rights, adoption pay, etc., that increases from £156 to £66 to £172.48. So again, a sizable increase. But again, if you look at the levels, certainly if we're looking at the take-up of shared parental pay, I don't think it's going to help address that. The imbalance that we all know there is that women tend to take maternity leave and men don't tend to take paternity or shared parental leave because of they tend to be the major breadwinners in a lot of families and therefore can't afford to suddenly reduce down to that sort of level of salary. So it doesn't address those issues, but the increase will be welcome. A week's pay increases goes up from £571 to £643. Now, a week's pay is used, of course, to calculate a number of things, such as statutory redundancy pay. And so if you've done statutory redundancy payments calculations, saying at the start of the year for redundancy programs that are going to kick off in April or May, you may just want to revisit your calculations because you may have been using the wrong rate. You now need to use the £643 rate to calculate your statutory redundancy pay. Unfair dismissal compensation jumps from £93,878 to £105,707 for the compensatory awards. That's alongside the basic award for unfair dismissal. That compensatory award, is largely for financial loss. But, you know, look at the level of that. Now, I can remember when I first started practicing, which admittedly is a long time ago, you know, I think the level was something like a £12,000 maximum compensatory award. Now, of course, given the length of time that's passed since then, it's inevitable that it's increased, but £105,000 is a sizable potential penalty. And if anything needs to focus your attention on making sure you get dismissals correct, I think it's that sort of level of award. And certainly, I think moves away, doesn't it, if we needed to move away at all from this view that employment tribunals are this informal sort of knockabout industrial jury. They're a court, and the penalties for breaching certainly unfair dismissals is significant, as is the penalties for discrimination. And we see that with the rise and the increase in the vento bans. Now, the vento bans refer to how you calculate injury to feelings awards for discrimination. So not only are employees entitled to financial loss, they get an injury to feelings award for the upset and distress that has been caused, which, if you think about some sexual harassment cases, could be significant. The vento bands really split those awards into lower, middle, and upper. The lower bands increasing to it's 1,100 to 11,200, middle band 11,200 to 33,700, and the upper band 33,700 to £56,200, and that could be on top of any other financial loss compensation awarded. And again, I think just points to, doesn't it, the significance of following good process, revisiting things like sexual harassment prevention practices in your workplace to make sure you're avoiding the claims, because the cost of compensation is hugely significant and only ever increasing in this day and age. Now, I appreciate that's a whistle-stop tour through what I think is the current state of play of the employment law reform landscape at the moment. I'm going to hand over to Lindsay, who's going to deal with a bit of case law update. So hopefully you found that useful, and over to you, Lindsay.
Thanks, Matt. Good morning, everybody. So I'm just going to share my screen. Okay. Please let me know if anybody can't see that. Okay, so we're going to be going through, got 5 cases for you this morning. And we are starting with the case of Lafar Cisse and Western Sussex University Hospitals NHS Foundation Trust. That's a bit of a mouthful. And this case concerned the question of whether a previously concluded disciplinary process can be reopened. So Miss Lafar Cisse was Associate Director of Transformation for the NHS Trust, and she was responsible for improving race equality across the trust. Now, there were several incidents and allegations against Ms. Lafar Cisse of bullying and victimisation of one employee and harassment and discrimination of another. She was subsequently disciplined for this. She denied everything, but she was issued with a final written warning. Following this, and separate to this, there was a CQC inspection, so a Pair Quality Commission inspection of the trust, and the trust concluded that bullying was rife across the trust. And so another NHS trust took over management of this one. The managing director of the new trust felt that Miss Lafar Cisse might not be a proper fit for her role, given that the nature of her role was to promote and improve race equality across the trust, and she'd been accused of bullying, harassment and discrimination. So the disciplinary was then reopened. So she had to go through another disciplinary process on the same issues as previously. She denied any wrongdoing, but she was dismissed on the ground that her conduct had fatally undermined her ability to do her role effectively. She then brought claims for unfair dismissal. In the first instance, the Employment Tribunal rejected her claim on the grounds that the trust had a fair reason to dismiss, which was some other substantial reason, and that the process that had been adopted by the new trust was reasonable, and therefore the dismissal was fair. Miss Lafar Cisse still refused to accept any responsibility for her conduct, and she then appealed the decision to the Employment Appeal Tribunal. And she said that the trust should not have reopened those previously concluded disciplinary proceedings. Now, the EAT in this case used a previous case of Christo and London Borough of Haringey when they made their decision. And they used that case because in that case, the Court of Appeal said that the doctrine of res judicata is when previously litigated issues cannot be relitigated and cannot be reopened. Court of Appeal said that that res judicata doctrine doesn't apply to disciplinary proceedings. So in other words, disciplinary proceedings that have been reopened, that have been concluded, can be reopened. And they said that the trust was not precluded from fairly dismissing Ms. Lafarcise for the matters that had already been determined in a previous disciplinary process. However, they did concede that reopening those disciplinary proceedings is fairly unusual. But they said that the previous tribunal, the employment tribunal, hadn't made any error of law in their decision making, and they provided clear reasoning for everything that they had decided, and the dismissal was fair in all the circumstances. So this case confirms that you can reopen disciplinary proceedings that have previously been concluded. But what we would say about this is the circumstances of this case are quite unusual, and you would have to have exceptional circumstances to justify any reopening once a disciplinary process has concluded. Obviously, in this case, we've got new management taking over a business, a trust, and they needed to investigate concerns and they needed to make improvements. And they could also rely on the CQC report when reopening Ms. Lafarcise's disciplinary proceedings, and they did have grave concerns about her ongoing suitability in that role, given the nature of the role. So if you ever find yourself in this position, we would obviously advise you to take legal advice. You're not precluded from reopening disciplinary proceedings, but you'd have to be careful about how you did it. Alternatively, you can reopen previously concluded disciplinary proceedings if new evidence comes to light as well. So now we're going to move on to the case of Ellis and Bacon and Advanced Fire Solutions. So this is a case concerning marital status discrimination, which you don't see very often. And this is about a director who was dismissed while divorcing her husband, who is also a director of the company. So Mrs. Bacon joined Advanced Fire Solutions in 2005, and she became a director in 2008 and married Mr. Bacon that year as well. Mr. Ellis, who was also subject to proceedings, joined the business in 2012, and he became managing director in 2017. Also in 2017, Mrs. Bacon told Mr. Bacon that she wanted to separate, and divorce proceedings then ensued, and they were particularly acrimonious. False allegations were raised against Mrs. Bacon concerning misuse of IT and theft. She was suspended from her role, and she was subsequently dismissed in 2018 by a letter signed by Mr. Ellis. She then brought claims of unfair dismissal and direct discrimination on the grounds of marital status. Now, the tribunal found that Mr. Ellis had sided with Mr. Bacon in relation to the marital dispute and the general divorce proceedings. He was on his side. He was compliant and complicit with Mr. Bacon in removing Mrs. Bacon's directorship, not paying her dividends, also calling the police on her in relation to these allegations that turned out to be false against her. They suspended her and they dismissed her. She'd also raised a grievance about her treatment, and that had remained unresolved as well. So the tribunal unanimously concluded that she had been discriminated against on the grounds of marital status. They found that Mr. Ellis had distanced himself from her, and he was basically Mr. Bacon's stooge. Mr. Bacon was the one who was pulling the strings, if you like. So the tribunal held that she was fired from her role because she was married to Mr. Bacon. Now, Mr. Ellis appealed this decision, and the appeal was allowed. And the issue here was whether Mr. Ellis treated Mrs. Bacon unfavourably because she was married. The question was not, was she badly treated because she was married to Mr. Bacon, i.e. a particular person. So another way of looking at this issue is to say whether an unmarried woman whose circumstances were the same as Mrs. Bacon's would have been treated the same. So in other words, somebody who was in a close relationship with Mr. Bacon, would they have been treated differently? And if the answer is no, then there is no marital status discrimination. So the appeal tribunal said that it was plain that the tribunal obviously had felt badly for Mrs. Bacon because she'd been treated particularly shoddily in this situation, and the merits looked clearly in her favour, but there was little case law to guide the tribunal, because we don't see these kind of cases very often. People don't generally tend to go around discriminating against married people or against people because they're married. So the EAT said that the tribunal had failed to address its mind to the real issue, which is the comparator, the hypothetical comparator. Would an unmarried woman in the same situation as Mrs. Bacon, i.e. in the close relationship with Mr. Bacon, have been treated in the same way? So they overturned the decision, and Mrs. Bacon lost her claim, and this is again a very rare case. These kind of things are overlooked. You don't really see marital status discrimination very often. If you ever did come across this, it would probably normally be within a family business such as this, and you would have to emphasize, if you were going through a dismissal with a married person, that the reason for the dismissal is not because they're married, but because they're married to a particular person and because of the nature of that close relationship, as in this case. So we move on to the case of McQueen and the General Optical Council now. So this is a case of a claimant who had various disabilities: Asperger's, dyslexia, hearing loss. He was also neurodivergent, and this gentleman, this claimant, had been disciplined at work because of incidents of aggressive behaviour against colleagues and his manager. He brought claims in the tribunal, and the tribunal found that the claimant's conduct was because he had a very short temper and because he didn't like being told what to do, that it was not because of his disabilities. And the claimant argued that the tribunal should have considered whether or not any of his disabilities had been a factor in his conduct, meaning that the disciplinary action was due to something that had arisen out of his disability. He then appealed to the Employment Appeal Tribunal, who rejected this argument and found that disabilities did not play any part in the conduct of the claimant. So there was no need to consider whether the treatment was partly because of his disabilities. So they just said he was aggressive and he had a short temper, and that was actually nothing to do with his disability. But the EAT said that there's 4 questions that you need to ask in this situation. First, what are the disabilities? Secondly, what are their effects? Third, what unfavourable treatment is alleged in time and proved? And finally, was that unfavourable treatment because of an effect or effects of the disabilities? So in this case, it was found that his behaviour wasn't because of his disabilities. But what I would say about this is, if the tribunal had found that he was disciplined because of issues arising from his disability, then potentially the respondent, the employer, could argue that there was objective justification for this. So I think if you're ever in this situation, if you're managing individuals like this, first make sure that you've got all the medical evidence so that you can answer the questions: what are the disabilities and what are the effects? And then you would also have to keep a good paper trail of any incidents of aggressive behaviour or other behaviour with colleagues or management or customers or something like that. That would help your defence. Take advice on any potential disciplinary or dismissal, and note that you're not precluded from dismissing somebody because they're disabled. You just have to be careful about it, and you may be able to objectively justify any disciplinary action or dismissal if their behaviour was causing other problems. Okay, so now we're going to move on to the case of Mobbs and Weetabix Limited. So this is a case regarding bullying and harassment. This particular employee left his job after having to endure bullying, shouting and offensive behaviour from his line manager, and it was found that he'd been constructively unfairly dismissed. So he was a health and safety and environmental manager for Weetabix, and he claimed that he'd experienced inappropriate bullying and harassment from his line manager, Mr. Petrie. So some examples of this: Mr. Petrie's management style involved using words to humiliate employees, to supposedly get the best out of people. He would hold employees to account, often in a public forum, so in front of people. He felt they'd done something wrong. On one occasion, Mr. Petrie and Mr. Mobbs had a phone call about moving a meeting clash, and Mr. Petrie had said to Mr. Mobbs, "Don't inconvenience me with your poor organising skills, sort yourself out." He'd also referred to a colleague as useless and an effing idiot. And then in 2019, there had been a meeting where Mr. Petrie had shouted at Mr. Mobbs and refused to let him speak, and accused him of various things, including jeopardising the commercial interests of the business. And so Mr. Mobbs had raised a formal grievance about Mr. Petrie. The grievance was took a long time to be investigated, and his grievance was not upheld, and he appealed, and that was also dismissed as well. He was signed off sick by his GP, and he eventually resigned and brought claims against Weetabix. The employment tribunal found that Mr. Petrie's behaviour was sufficiently serious to breach the implied term of trust and confidence in the contract of employment between Mobbs and Weetabix. And they also said that delays in handling the grievance were not reasonable, given the size of Weetabix as an employer, and also given the evidence that had been gathered as part of that investigation. They were also very surprised at the outcome. The grievance wasn't upheld. The employment judge said, Mr. Petrie at the tribunal told the tribunal that he was familiar with Weetabix's dignity at work policy, and he did understand that some of his communication could be deemed offensive. And the employment judge said that Mr. Petrie's management style and his ambition to get the best out of colleagues by humiliating them was not reasonable, and no excuse for the language that he was using. He was unprofessional, his language was offensive, and that was likely to destroy the term of trust and confidence between employer and employee. So I think the key takeaway from this is, don't just pay lip service to policies, train managers so they know that they can't treat staff like this, and also make sure that you deal with any grievances without delay. And now we're going on to the case of Mrs. Mogane and Bradford Hospital's NHS Foundation Trust. So this concerns the case of a nurse, Mrs. Mogane, who was on a fixed term contract with the Bradford Hospitals Trust. She had worked there under a series of fixed term contracts since 2016. Now, a new second nurse was contracted to the trust to work on a 2-year fixed term contract. In 2019, Mrs. Mogane was invited to a meeting to discuss the fact that the trust was in financial difficulties. And shortly after that, they decided that Mrs. Mogane should be made redundant because her fixed term contract was coming up for renewal. By the time that they'd consulted with her about the renewal of her contract, they've already decided that her role would be made redundant. So the remainder of that process then consisted of the trust trying to find alternative employment for Mrs. Mogane. That wasn't possible, so Mrs. Mogane was then dismissed by reason of redundancy. She brought claims against the trust for unfair dismissal. The employment tribunal dismissed her claim, so she was unsuccessful in the employment tribunal, and she then appealed to the appeal tribunal. The EAT held that the consultation should take place at a formative stage of the redundancy process. So at the beginning, at a stage where the employee could potentially influence the outcome of that. So you can say that that consultation is genuine and meaningful and fair. So the EAT had noted that once they decided that her contract was up for renewal, she should be the person to be dismissed. And obviously that was never going to be a fair dismissal. So any consultation from that point onwards was basically going to be a bit futile. So I think the key takeaway from this is you are going through a redundancy consultation process with your staff. Start that consultation at an early stage so that you can show that that employee could potentially influence the outcome. So they could make suggestions as to the selection criteria or the selection pool, should somebody else be added to that pool alongside them. And that way you've got much more chance of showing that that is genuine and fair, and that you've adopted an objective and fair and reasonable criteria. So we are now at the questions stage. So I will just stop sharing my screen now. Should be able to see Matt again.
Hello, everyone. Thank you, Lindsay, for that. That was really good. I'm just going to share my screen again. So questions. Actually, I was looking at the Q&A. I don't think we've actually had any questions in, Lindsay, unless I'm pressing the wrong button. Which
no, I haven't seen any either.
Yeah. One of the things, not necessarily a question, but I did see more as an observation, and one no doubt we'll cover at the next session if the decision is made by then, that the Uber decision is gone to the Supreme Court yesterday on basically trade union recognition, but it could have a significant impact in terms of employment status. So I think that could be the next big one that's coming along. But I don't think we've necessarily had. Okay, I've got a question. What's the difference between reopening disciplinary and opening a new one? Do you want?
Yeah, do you want me to answer that? And then if you've got anything to add, Matt.
Yeah, sure.
Because we occasionally do get these questions.
Yeah.
So I think that would be something like, if you are going through the same set of circumstances and the same set of facts that you've already made a decision on. So in this particular case with Lafarge, they had already been through everything that she'd done. So all of the allegations, they'd been through the investigation, and they'd held the disciplinary hearing with her, and they'd given her a written warning. And when it was reopened, they went through exactly the same process, just with a different chair of the disciplinary hearing and a different outcome. So everything was still the same in that case, which is why it's kind of so unusual, and we say it's exceptional circumstances to reopen it. So a new one would be, for example, if other things had happened subsequently. So you were opening something with new allegations and a new set of circumstances, or additional set of circumstances as well.
Yeah, I would agree, Lindsay, and I thought the point that you were making that it's one of those cases which you look at and you think, oh, that's interesting. I think I would be loath to advise in most cases to reopen a disciplinary hearing. That I think tribunals will always scrutinise that, and I think that the case I thought that case was kind of an exceptional set of facts rather than something that you should rush to do. I think if you're having a disciplinary, the idea is that you should get everything dealt with. I think tribunals sometimes get suspicious that perhaps employers are keeping stuff back to then suddenly launch into the next round. You're giving someone a final written warning, but you've kept some acts of misconduct back that you can immediately then just start on the dismissal process. So I would always be loath to reopen a disciplinary unless there's absolutely exceptional circumstances. Yeah,
agreed. And they'd also got the backup of the CQC with this, because the CQC had done a report subsequently, which was quite damning. So they were a new trust that had to improve and investigate. So it was very different circumstances.
Yeah, we've had a question around 2P and the EU reform bill, and the question is, if an organisation is going through a 2P process with an estimated date, presumably transfer date of 31 December, if the bill passes on the 31st December, what will happen to that particular organisation's 2P? The really simple answer to that is I don't know, because the EU reform bill doesn't deal with what happens to that sort of transition process. I suspect that what they would have to do is make some determination as to when the transfer takes place. But in theory, if you had a transfer which took place on the 1st of January 2024 and 2p has disappeared, then you wouldn't have needed to have complied with all aspects of that. But what about the consultation that should happen before the transfer? So I think I can see it being hugely problematic, and it's for exactly those sort of questions that I think the government needs to pay some proper attention to this bill, rather than just letting regulations just disappear without thought as to how it's actually going to work in practice. So a great question, one that highlights the problems of that EU reform bill, and one that I don't know the answer to off the top of my head. We've had a question come through about the Mogane case, about why did they need to go through a formal redundancy process as if the contract was finishing. Surely they only had to have a meeting to discuss whether or not it was going to be renewed.
Shall I answer that? And
Yeah,
then
yeah,
you can add,
yeah.
You can add to this, Matt. Because she'd been there since 2006, so she would have had, because even though she was on a series of fixed term contracts, she would have then have accrued her rights and her continuity of service. So if there is a redundancy situation, you'd still have, even though the fixed term contract is coming to an end, you still have to go through a proper process when you're going through that dismissal.
That was my understanding, Lindsay, is that because non-renewal of a fixed term contract is treated as a dismissal, and therefore employees can still bring unfair dismissal claims on their non-renewal of a fixed term contract, you should deal with it as if you would deal with any other redundancy process and consult, which I think was the issue there. And I think we've got time for one final question, which is about the McQueen case, Lindsay. So if McQueen's difficult behaviour had been an effect of his disability, what is the subsequent reasoning that still might permit dismissal?
Yeah, so there's a potential that you could objectively justify that. So, for example, if we would always say to get legal advice on this, but if you had a very difficult employee, they were disabled, and for example, the effects of their disability was that they were, aggressive or rude to customers, or nasty or violent towards their co-workers or managers, then obviously you'd have to deal with it in the correct way in terms of any potential disciplinary or dismissal. But you could objectively justify that kind of dismissal by saying that although it was effective the disability, it was because of the disability or because of the effects of the disability, you can't have your customers and co-workers being treated aggressively or fearing for their personal safety because of their colleague.
Yeah, I think I would agree with that entirely. It doesn't ring fence the employee from action in those circumstances. I think you'd have to be careful, and there's reasonable adjustments to consider and things like that. But ultimately, if someone's difficult behaviour had been in because of their disability, then you could still say objectively justify the dismissal in those circumstances. It gets a little bit more difficult. McQueen avoided that, I think. I think the tribunal avoided having to make that decision quite neatly. I think that deals with the questions that we've got to date, which means we're finishing, I think, bang on 11. Just a quick plug for our next webinar, which is going to be on the 14th of June 2023, which is going to be all about allyship, about how you can develop allyship programs within your organization, which is a key really for a lot of D&I policies around supporting staff around equality and diversity in the workplace. I think it'd be fascinating. It's likely to be limited numbers because it's going to be quite an interactive session. I won't reveal too much, but those of you who hear me bang on at webinars enough will be pleased to know I will be doing very little speaking on that, and I'll be handing over to some fantastic presenters to take us through. So when you do see the invite come through for that, I would encourage you to register early, because we're likely to have limited numbers, as I say. Well, thank you very much on behalf of Moorcrofts for joining us. Hope you found it useful. As I say, the follow-up will come through. We'll send you the link to the recording and the slides and the kind of flyer with the rate changes, so you've got that all in one place. And if you've got any queries or questions beyond that, just let me know, and and if we have got any additional questions that we weren't able to answer, we'll try and get those as well. So thank you.
Thank you.